A couple of months ago, the Nigeria Bar Association section on business law announced that its renowned annual business law conference, which has been on for the last 13 years, will be going online for the first time and we will be having thousands of participants. Well, joining us now to discuss this is a lawyer and senior advocate of Nigeria, Seni Adio. Seni Adio is also the chairman, MBA section on business law. Welcome to Newsday. And I'll start it off by asking, how is the law profession in general, before we even come into business law, how is the law profession in general adapting to the new COVID normal?
The law profession is adapting. A lot of law firms have what we call business continuity programs that they've implemented, essentially using technology to be able to stay connected to their clients and various stakeholders so that they can continue to provide services to clients. So for the most part, law firms have been working and working very hard, albeit remotely, to make sure that to the extent possible, business continues as normally as otherwise would have been the case pre-COVID.
Well, it is anticipated that post-COVID-19, whatever that looks like, the legal fraternity would have a huge demand on its expertise. What's your thought on that, and what is likely to change?
It's true that, I anticipate that business will continue to grow. What is likely to change in some dramatic fashion, I think, is that what is been described as the new norm, which is having flexi hours, working from home, using technology to interact with clients, even amongst professionals, even in my firm, for example, a lot of our staff meetings are done virtually, remotely. That will continue for the most part, even when things normalize, so to speak. But also, I think a lot of firms have realized that it's very important to maintain that good mix in terms of your practice areas. Some firms have been, shall I say, COVID resistant. The COVID-19 hasn't impacted some certain sectors of the economy, particularly pharmaceuticals, healthcare, logistics, to name a few. So it certainly behooves law firms to make sure we look in that direction, to make sure that we have a full complement and a good mix in terms of our practice areas, so that when one area might be slightly impacted, it doesn't have to be pandemic, with something else, but at least you have some level of sustainability.
So, Seni, since you're an aficionado of business law, how are they incorporating the new normal into business law, and how is it even impacting the way things are being done right now? Now, trying to vista it in home, I want to hear from you concerning what needs to be, what should be done to be able to bring ourselves, first of all, up to par with international best practices and also with the reality of COVID-19.
Well, I noticed when you were making the introduction, you actually described our conference, the SBL conference, the Nigerian Bar Association Section of Business Law Conference, as renowned. And that's in fact correct. That wasn't lost on me. It's world renowned. Now, to answer your question, like I said, technology is very, very important. That has to remain. That going forward it becomes the norm to use technology to interact and engage with clients online, real time, 24/7, 365 days a year. A lot of the firms, you see, the thing is that we don't give ourselves enough credit sometimes, because, like I said, many law firms actually have been working almost seamlessly since post-COVID. As a matter of fact, in some instances, you have to make a conscious effort to know when to draw the line and stop, do a hard stop. Some firms have found that maybe their lawyers are even busier, so to speak, during this period because they've been working almost round the clock. So the COVID has had certain devastating effects, particularly in terms of lives lost and things of that nature. But I think for the most part, law firms have been resilient. Certainly some have been more resilient than others. But for the most part, I think the technology had always been there anyway. It's just that we're now sweating the technology. All these platforms, they're not new. I mean, some of the ones that we don't even talk about Skype anymore, for example. Skype has been around for a long time. So we're talking WebEx now, Zoom, Teams, Google Duo, and so on and so forth. they've been there for ages. It's just that now we're using them. And as a matter of fact, someone like me, I've found them so useful that oftentimes I actually don't look forward to leaving my home, sometimes even to go to the office. So I think firms will continue to leverage on technology to make sure that they stay connected with their stakeholders, particularly clients.
As interesting and fascinating as this new norm or the old ways we are adapting to as the new norm sounds, I would like to ask if the existing laws actually cater for this new reality. For instance, the Evidence Act in Nigeria. You're talking about Zoom and Skype. Does the Evidence Act provide for that? Electronic signature. Should I have a meeting or a contract with you over Zoom or Skype? Would that be tenable?
Actually, it would be tenable, and that's the whole point, that up until now, people didn't pay attention to some of these provisions in our laws. And the thing is that, even before the pandemic, people could give evidence virtually, electronically, because sometimes it may just not be convenient for a particular witness to be able to come and be in court physically. So oftentimes you'd have to do it electronically through video conference. Now, what would happen is that in that case, using a courtroom example, as an example, you would have to make an application to the court, give notice to opposing counsel, i.e. to the other side, that that's what you intend to do, to have the witness give the evidence virtually, so to speak. And then the witness can be cross-examined. And as you would have in the courtroom, the court can evaluate the credibility of that witness by observing the witness and so on and so forth. It's true that, yes, there's still some challenges because internet connectivity could pose a challenge. Loss of transmission could pose a challenge, because if there's a loss in transmission, query whether it was contrived, for example, God forbid, or was actually a break in transmission, and the things that can happen between the break and when connectivity resumes. But it's something that's going to get better. To answer your question about electronic evidence or signatures and things like that, even what would happen is, if you bring a document to court and it's been signed electronically, there are certain foundations that a lawyer would have to lay. And once you lay the foundation, the document, if it's otherwise relevant, because the predicate for any information, whether it's documentary or testamentary, to be admissible in evidence, that it must be relevant. That's the predicate. If it's relevant, then the court will admit it and then determine what weight to give to that piece of evidence.
All right, Seni, as we build up to next week's 14th Annual Business Law e-conference, titled Business Unusual, I want to find out what unusual ways, what are you bringing into the law practice? Because in that particular flyer, it's been written that you would want to explore disruptive ways. Is it just lip service, or are there things already on ground that would actually disrupt the way law is actually practiced in Nigeria?
But you already conceded that it's we don't pay lip service at the SBL. but to answer your question, I mean, the platform that we're using is called the Hopin2Go platform. It's going to give the delegates, our e-delegates, an actual conference feel, touch and feel, and conference experience. So, for example, once you log in and you're in the conference, so to speak, you don't have to log out to be moving from different sessions to another session. You're in there. It's like going from one room to another, depending on what session you might be interested in. It's unusual because for the first time, we're having an entire conference. It's not a webinar. It's an actual conference with very substantive issues being interrogated, and in the SBL tradition, we're going to be proffering practical solutions to those issues. It's going to be like as we had it last year. Last year, the conference was declared open by Chief Justice of Nigeria, Justice Ibrahim Tanko Mohammed, CJN, CFR. He had it declared open. He was ably represented by Justice Ruth Viver of the Supreme Court. We had the Honorable Speaker, Femi Miller, and His Excellency Babajide Fashola, Governor of Lagos State, as dignitaries. We had heads of course, and we're going to have the same thing this year. As a matter of fact, it's a good segue to sort of amplify the fact that we're going to be having, and I think perhaps it'll be the first time, we're going to be having a former law elected official as our keynote speaker distinguished Senator William Moe Cowan, former senator for the Commonwealth of Massachusetts, brilliant politician, brilliant legal practitioner, currently a president within the General Electric Corporation conglomerate. He's going to be with us. He would have pre-recorded his message, but he's also going to be with us live, so we can have a very, very interactive opening ceremony in which he too would be participating and observing. So it's going to be packed with all kinds of very interesting issues to be discussed. Our first plenary is going to be moderated by no one other than Aswe Igudalo, who we all know is an astute business lawyer and a director of many leading organizations and chairman of some leading business organizations as well.
Well, thank you so much, Seni Adio, Chairman, NBA Section on Business Law, and wish you the best in this conference.